I'll tell you, regardless of what she finds out, I think I'm ready to make a ruling. But before I do, let me ask you this. Is the Commonwealth prepared to go forward with the evidence as it stands? If I don't let you use the Cellbright reports, for example, or the information in any format other than what's already been disclosed, is the Commonwealth ready to proceed?
I believe so, yes.
Even if it means comparing page 1 to page B.
And that's the problem. But I have enough confidence that the data that has been provided. Now, well, let me say this: if between now and trial there's an attack on our evidence, saying, "Well,
I'm getting to that.
it's incomplete," then if it guts us, then or it's ruled inadmissible, then I'm saying no, we can't be ready because so that
I'm on top of that, counsel.
Thanks, sir.
I'm going to rule that the evidence that has already been provided, that has been in the hands of the defense for a long time, will be the evidence that the Commonwealth is allowed to present. The Commonwealth is ordered, however, to disclose everything it has to the defense attorneys under the protective order. No further disclosure to third parties will be tolerated. Now, as far as the exculpatory aspects of this evidence is concerned, my view of it is that anything that is exculpatory is going to be in a very narrow window. And the hopefully there is technology that will enable that window to be narrowed even further, so there won't be great difficulty in finding exculpatory information, if any there be. But even if there isn't, I think that looking at the data that you already have and you're probably already infinitely familiar with, you shouldn't find anything new if you've looked at the data you already have. After all, this information that is coming out is not new information. It's just a new way of looking at it or manipulating it, to use that word. So I really don't see the prejudice to the defense, since you've already had the opportunity to digest the information you have. And plus, as Mr. Heck has pointed out, these phones have been available for examination for all this time, and only Mr. Schaus has asked to take them and have them tested, and I don't think he took all of them even then. So, but here's the third leg of this stool. I think this eventuality is unlikely, but if any of the defense attorneys in good faith, can say that there's something that they have found that's exculpatory that will require them to ask for a continuance based on what they found, I will reconsider. But that's the only reason why I would reconsider my ruling that the trial proceed as scheduled.